Every great business story starts with a bold decision. The decision to step out, take control, and build something of your own. Entrepreneurs are not made in comfort zones. They are made in moments of courage. Moments when you decide to move forward, lead, and grow. Welcome to ISFA, Indian Small Business and Franchise Association, the driving force behind India's thriving small business and franchise community. Since 2008, we have stood alongside India's MSMEs, enabling ideas to become enterprises and entrepreneurs to become leaders. Today, over 6.3 million MSMEs in India are growing, learning, and expanding with ISFA. With 1,200 plus live events every year and more than 1,500 industry enablers as partners, ISFA is a dynamic network of opportunity. We're shaping India's franchise future with fairness, transparency, and trust. At ISFA, we connect ambitious business stories to top global and Indian franchise brands and build. Whether you're starting out or entrepreneurs are not ISFA gives you the platform to grow with funding support, skill building programs, and international trade access. We help you unlock your potential. Small businesses don't stay small for long with ISFA. They become tomorrow's success stories. So take the lead. Join ISFA today. Let's build the future of entrepreneurship together, enabling ideas to become enterprises and entrepreneurs to become leaders.
Good afternoon, everyone. A very warm welcome to all of you to joining us for today's webinar on MSME sector, how to deal with commercial dispute and intellectual property rights. We are thrilled to have you with us for this virtual discussion, particularly as a startup and MSMEs face increasing challenges in managing commercial and disputes and safeguarding their intellectual property. Today's session will provide essential insights and practical strategies for effectively handling commercial dispute and protecting IP. Two key areas for MSMEs navigating today's competitive and complex business environment. It is my pleasure to introduce our esteemed speaker, Mr. Aman Abhinav, partner of Phoenix Legal, and Ms. Neha Nayak, partner of Phoenix Legal. Both brings vast experience in dispute resolution and intellectual property law and will offer valuable guidance on how MSME can address these critical issues. We would also like to extend our sincere gratitude to our knowledge partner, Phoenix Legal, for their invaluable support in making this event possible. Thank you once again for being here. We look forward to an engaging and informative session. Without further delay, I now hand over the floor to Mr. Aman Abhinav to begin. Sir, over to you. Please start the session.
Thank you, Akshay. Thank you very much for the warm welcome and the introduction. I thank ISFA as well for this opportunity to partner on this knowledge sharing session, this webinar on where we'll be dealing with and talking about the legal challenges that are faced by MSMEs from a disputes perspective, as well as intellectual property rights, which will be dealt with by my colleague Neha. Just before we start, just wanted to briefly introduce the firm and ourselves. Phoenix Legal is a full-service law firm with offices in Delhi and Mumbai. We are about 23 partners and over 100 lawyers, and we provide services across sectors from on the corporate side, pertaining to corporate advisory, contracts, contract negotiations, drafting, mergers and acquisitions, private equity, banking, law, related queries and dispute resolution from commercial disputes to investigations, white collar crime, as well as criminal offense under different statutes. So that is the sum and substance of what we do. And my colleague Neha, who is also a disputes partner and focuses on intellectual property rights, I would let her speak on her expertise when and share with you what she does. As far as I am concerned, I deal with commercial disputes, arbitration, and dispute resolution in general, and I focus on white collar investigations and defense work. So, without further ado, let's jump into the session today. Let me just give me a moment to share the slide which I have prepared so that it's easy for everyone to refer to. Is this visible? Yeah. So what we are going to discuss today is challenges that are being faced by MSME from a disputes perspective. The later part will be respecting intellectual property.
Abhinavji, I think if you put it in a full screen view in the bottom of the PPT. This is next last one. Yes. No. Yes, this one.
Yeah. Yeah. Is this better? I mean, is this visible now? Right. I would assume that this is visible.
Yeah, it's visible, Aman.
It's visible.
Nice. Now, when we talk about the MSME sector, there is no doubt that MSME is currently the backbone of the Indian economy, and I don't say this out of a whim, but this is based on statistics which are there in the public domain. If we talk about statistics, MSMEs contribute about 30% of the GDP and 45% of the exports out of India. It generates it employs about 20 crore people all across the country. And there are about 6 crore MSMEs currently functioning, and this number keeps adding every year by about 1 crore. So therefore, it won't be a gainsay to say that MSME sector today is a driver of innovation, industrial output, economic growth, trade, and development. It is for this reason that the government saw potential in the growth prospects of this industry, or of this segment rather, that in the year 2006, the government brought this specific legislation called the Micro, Small and Medium Enterprises Development Act 2006. Now, the objective of this act was to streamline the legal procedure that were to be followed by the MSME sector, or rather applicable to them, because as the name suggests, these are not very large entities, right? They have they operate across spectrums of economic abilities, and so therefore these entities deal with economic issues, cash flow issues, and so therefore the government felt that there should be a process where there could be an organization which could deal with all their problems with respect to payments and the performance of contract, etc. And all the disputes could be dealt with under a umbrella organization. And so that is why this statute was conceived. Now, as we go deeper into this, what I would like to do is first talk about what the statute does and what is the general framework under the statute, and then talk about what are the various issues that are currently being faced by the MSME sector. And then I would also take you through certain legal examples, case studies where MSME sectors are currently dealing with certain sort of lacuna and legal uncertainty. And also, I would touch upon certain instances where criminal action could also be initiated by the suppliers under the Act to safeguard their interests. Now, give you a flavor of what is entailed. I've already told you that we will talk about the legal framework to begin with. Then we'll talk about the cases that are commonly seen, the issues, and therefore thereafter legal action. Now, coming to the legal framework governing dispute resolution under the MSME Act. What the question that one must ask is, what is the procedure for dispute resolution under the MSME Act in cases where a buyer defaults on payment, and what legal recourse is available to an MSME to enforce its rights? Before answering that question, one has to also see as to what does the Act do or provide for the MSMEs. Now, according to me, there are 6 benefits that the Act confers on MSMEs. The first benefit for suppliers is that it fixes a date for payment. Now, under a contract or even otherwise, once if you offer a service or make sale of a good, of a product, then generally either there is a understanding of when the payment would be made, or it's agreed otherwise. Under this Act, the government has mandated that if a person buys a product or takes service from an MSME unit, it must make the payment within 45 days. And this 45 days is an outer limit. So a party or 2 parties or an MSME is free to prescribe a shorter date of payment, which is within the time limit of 45 days, but it can't be beyond that. The second is the consequence for delay. Now, what happens in a situation that, even though, generally when we also purchase products or enter into contracts for sale of goods or services, there is generally an understanding. Either there is a stipulation under a contract that there would be interest chargeable, or most of the times it's not. So something that is unstated and ambiguous. So in such situations, there is a statutory mandate which is imposed on, or a liability rather, which is imposed on buyers, where the buyers are made liable to pay compound interest in case they fail to make payment under the 45-day period, and which is quite an exorbitant amount, because the percentage that has been mandated under the Act is firstly compound interest, which is 3 times the bank rate. Now, RBI bank rate currently is about 6.5%. So 3 times that would be above 18-20%, which is quite a sizable sum. Now, thirdly, is the liability of the buyer to pay this amount. So suppose there is a delay in payment by the buyer, then there is an automatic levy of this interest on the buyer when he makes the payment. So whenever he makes the payment after this 45-day period, he has to pay interest, whether or not this was contractually agreed or conceived or not. Fourthly, the Act provides for a resolution mechanism. Now, of course, the sequitur to a dispute would be as to what happens when there is firstly a liability to pay. Secondly, either there is a non-payment, or there is part payment, or there is payment without interest. So clearly there would be a dispute. Now, once this dispute occurs, what is the supplier supposed to do? Now, the Act creates a body called the Micro and Small Enterprise Facilitation Council, MSEFC in short. There are every state has its own regulation rules under the MSMED Act, under which there are about 161 facilitation councils that have been created. Now, the job of this facilitation council is twofold. In the first instance, whenever there is a dispute, a reference is to be made by a supplier to the council. Now, interestingly, in order to facilitate easier and quicker resolution, a supplier can initiate an action against any buyer anywhere in the country as long as the jurisdiction of the facilitation council is clear. So, for example, if the seller is based out of Delhi, he can approach, the enterprise can approach the facilitation council in Delhi, even though the buyer is sitting in Bombay or Calcutta, for example. So therefore, the Act also simplifies this process of resolution where the supplier under the Act is given more power in that sense and ease of approaching a facilitation council. It doesn't have to go through the rigmarole of finding out which is the correct forum or facilitation council to approach. As long as it is within the territorial jurisdiction of a particular MSE facilitation council, it can approach it, and the buyer need not be from the same jurisdiction. Now, under the mechanism, so as I was saying, the facilitation council has a twofold mechanism that it follows. In the first instance, the council will act as a conciliator, and now, of course, a mediator, because after the 2023 Mediation Act came into force, it has amended a lot of provisions under the MSME Act as well as the Arbitration Conciliation Act, whereby references to conciliation has been omitted and mediation has been inserted in its place. So in the first instance, there'll be a mediation that will be conducted by the Facilitation Council. Now, under the Mediation Act, the duration for this mediation to complete is about 6 months. It can be done at any time before that. And mediation, as the word and the import of the word as well as the statute suggests, that it is something that cannot be mandated. It is voluntary in nature. So therefore, once the reference is received by the Facilitation Council, it will within 15 days send this reference to the buyer and ask for its comments and whether it wants to conciliate or not, or mediate or not. If the parties mediate and there is a resolution, then it will be a mediated settlement and it can be enforceable. Now, there will be situations where this mediation will not succeed and will fail. Then, in that scenario, there is a second secondary role, which the Facilitation Council So the secondary role which the Facilitation Council performs is that of conducting an arbitration. Now, it will also act as an arbitrator. And the process is that the reference would be then sent to the arbitrator, and the Facilitation Council can itself either act as an arbitrator, or it can appoint any institute which can operate as an arbitrator. The claims will be considered. The replies of the buyer will also be considered, and thereafter an award will be rendered by the council. Now, the fifth benefit under the Act, which is conferred on the suppliers, is that once an award is given, and now the buyer, of course, wants to get away from the liability, or try to sort of protect itself from the liability and not pay, it will obviously challenge the award. Now, under the Act, once an award is challenged under Section 34 of the Arbitration Conciliation Act, and specifically, the Act specifically provides that a necessary deposit of 75% of the award amount has to be made. So therefore, you cannot get away with the liability to pay without any consequences. So that is the fifth benefit. The last and the final benefit which I see is that the Act, MSME Act itself has, the provisions of the Act have been given an overriding effect over all other laws, which means, and which also tends to lend itself to all the other issues that we are going to deal subsequently, and primarily with respect to questions of arbitrability or existence of an arbitration agreement. Now, we'll discover later that in most of the disputes that arise between an MSME entity and a non-MSME entity, which is a buyer, the primary defense that the buyer takes is that there is a separate arbitration agreement under the contract, and so therefore there is no jurisdiction of the MSME to entertain this dispute. Now, in such scenarios, now one can always lean on this provision and say that, see, and which the judgments of the Supreme Court and various high courts have also held, that once there is an entity which is an MSME, and the fact that there are separate agreements providing for arbitration, that will not take effect, because the Act itself is supposed to be a special act which is enacted for the benefit of the MSME units, and so therefore the arbitration will be conducted as per the MSME Act and not the arbitration agreement which was entered into. So that, according to me, is the sixth benefit. Now, coming to what kind of legal disputes that we generally see in the MSME space. Firstly, of course, is the issue of delay or non-payment of dues by the buyers, which is the most obvious and the most repetitive issue, because because these entities are smaller entities, they are always cash strapped for in order to meet their demands and supplies, be competitive. They need easy cash flows. So, and that is the reason why the 45-day period was also introduced by the government under the statute. So the first issue that any MSME deals is that they have supplied either supplied goods but have not received payment, or they have performed services but have not received payment. And of course, that creates further issues in the supply chain for them. Secondary is the statutory period prescribed by the MSME Act. Now, this, of course, lends to the first issue, is that the Section 17 of the MSME Act mandates payment within an agreed period, which we have already discussed. So the remedy under that would be under Section 18 of the Act. So the moment there is a delay in payment, one should always right away issue a demand notice to the buyer and say that there is a violation. And another thing to note is also, which would be of relevance, is that in most cases that we have seen, that the MSME unit doesn't even make a demand, or most of them are not even aware of their rights under the Act. So when we are entering into a contract, that at that time itself, you should make them aware that you are an MSME unit. And so therefore, you should negotiate terms which are corresponding to the obligations of the buyer under the Act, which is the 45-day period limitation in payment. So your contract should also stipulate a term which is within that limit. Secondly, is that when you are raising an invoice, you should also mention at that point in time that you are an MSME unit, and therefore make corresponding iterations in the invoice saying that the invoice has to be cleared within such and such date. And if not, then the levy of interest under Section 16 you would be eligible for that. Right. Now, the other problem that most of the MSME face is that once you have an award in your favor, you've been successful, the difficulty is in enforcing that award, because there are several challenges to that. because the statute itself provides that once an award has been passed, the buyer has the right to challenge it. So therefore, that also create further delays in enforcing that award. And as we know, we have seen in multiple cases that these cases are not resolved quite quickly as early as it should, which also creates further cash flow issues for the MSME sector. So that is something that has to be seen and maybe perhaps could be ameliorated by the courts, where either MSME sector cases or awards are treated differently, or maybe there is a quicker disposal of such cases in general under Section 34. Now, there are other delays which are also attributable to jurisdictional challenges in dispute resolution. So now once an arbitration is ensued, there would be several defenses or challenges that would be raised by the buyer. Firstly, to contradict or counter the jurisdiction of MSME, which is the first and foremost of which is that the MSME Council is not registered under Section 8. And so therefore, or the other alternative argument is that when the time when the contract was entered into between the seller and the buyer, the supplier was not registered or had not filed a memorandum under Section 8. And so therefore, it's not entitled to the benefit under the MSME Act. The other objection which is generally taken is again of existence of a separate arbitration agreement, and so therefore that challenges the authority of the council, which although has now been settled in a catenae of judgments that such objection is not viable. However, buyers still often take those objections just to delay the process rather than subjecting themselves to arbitration and quicker resolution. Now, after the resolution, so we see that there is a tendency to delay at the conciliation or the mediation stage by either not participating or not being very forthcoming, or in most instances they use the mediation process also to dilate by unnecessarily stringing along the supplier and indulging in futile mediation efforts where the actually intent is to just delay and not come to the settlement table or mediate, frankly. At the second stage, when the arbitration is also going on, and mediation has failed and arbitration is going on, at that point also the tendency is to delay by taking frivolous objections. Now, in the third instance, which is post-award, once the arbitration is over and the award has been rendered, even then at that stage, in order to obviate the liability to deposit the 75% of the award amount, a lot of buyers in instances we have seen is that they, instead of challenging under 34, they approach directly under 226 of the Indian Constitution. They approach the High Court and challenge it in a writ petition. So that is also something that we have seen has been happening, where buyers try to pull a fast one on the suppliers by avoiding the entire MSME trajectory. Now, this is clearly an abuse of the process, and the other legal defenses which are raised to further delay payment or plausible defenses raised by the buyers is that they dispute the allegation, that they raise dispute with respect to the rendering of services. They say that the product was either defective, or the services were deficient, or that the product was not to a particular specification, or that there was a delay in performance of the services or the delivery of goods. And so these are the points that have to be considered by MSME at the time when the performance of the contract is being made. So therefore, you should always have stipulations where be very careful as to analyzing and maybe making note of what specific requirements are there under the contract and making corresponding stipulations when you're performing the contract. So suppose if there is a delivery to be made within a particular period, you should always, once the delivery is made, you should probably record that over a mail or by a correspondence with the buyer that the delivery was supposed to be made within such day, and or at least maintain the record of the date of performance, so that these can be used as defenses or counters to the defenses raised by the buyer subsequently. So the other issue which is generally seen, which is raised by the buyer against the supplier, and which is primarily at the challenge to the award stage, which is mostly to do with either principles of natural justice were not followed, or that the submissions were not considered, etc. So these are something these are the common challenges which we see, which are raised by the buyers, but these are something that one has to deal with as and when they are raised. And so therefore, in order to counter that, you should have proper responses available as to and it's also important at that point that the recording that the proceedings before the MSME council have been recorded properly, so that therefore the procedural orders which are to be passed are of great importance, and of course to ensure that you are also represented and present at every hearing is also quite critical. Now, another coming back to the issue which we had discussed a little bit earlier, I'd also flagged this issue that the buyers are also increasingly raising this dispute as to the jurisdiction of MSME council in instances where the contract between the supplier and the buyer was entered much before the filing of the memorandum, right? So basically what the buyers are contending is that since the contract was entered into much before you were actually recognized as a MSME entity, therefore you are not, the procedure that is available under the Act to an MSME is not available to such entity. Now there is some legal lacuna in that regard, because there are contradicting judgments of the Supreme Court as to whether this would bar claims against MSME entities who are not registered. The issues have already been framed by a recent bench of the Supreme Court, and has been referred to a larger bench, where it would determine as to whether the Act has been conceived as a beneficial legislation for MSME, and whether a supplier which has not filed a memorandum under Section 8 can still avail to the process which has been provided for, or the resolution process under the Act. And that particular judgment, which is NBCC, which was authored by Justice Narasimhan, he is of the opinion that MSME Act is a beneficial legislation, and there are wide wordings under Section 18 where any party can approach the the MSME Council, and it necessarily does not have to be an MSME entity. Because if you look at the definition of supplier under Section 2M, the definition of supplier includes not just MSME, micro and small enterprises, but also any other entity which sells or sells goods made by an MSME entity or services which are provided by an MSME entity. And so therefore, you need not file a memorandum necessarily in order to avail the benefits under the Act. However, that is not conclusive because we'll still have to wait for the judgment of the larger bench to reconcile the position with respect to the other two judgments which are contrary to the current. Now, the legal issues which I've already flagged, I think these are the iterations of the same, which is maintainability of writ petition filed on behalf of buyer and existence of alternative remedy under Section 34 of the Arbitration Conciliation Act. Now, the question which is pertinent currently is that whether such a remedy is completely barred or is still available. For example, there are instances where buyers, in order to skip their liability or get away from the liability to deposit once they have an award against them, they tend to file a writ petition. Now, in one of the cases, the question, which is Jharkhand Urja Vikas Nigam Limited, in that the Supreme Court had held that writ petition will still be liable, because in that case, the court was considering a situation where the MSME Council at the conciliatory stage itself had passed a complete award without even hearing the other party. And so therefore, in that specific scenario, the court had held that the writ jurisdiction will still be available because the award which was passed was in contradiction to the process which has been envisaged under the Act. And so therefore, it is completely contrary to the intent and the legal, the public policy. And so therefore, it's not an award at all. So if it's not an award, therefore, it cannot be challenged under Section 34. And so therefore, the remedy under 226 would still lie. Now, this has been a different view, actually, a view which is contradictory to this has been taken in India Glycol, where it said in that specific scenario, it acknowledged the fact that buyers are increasingly trying to avoid the normal method of challenging under 34 and depositing the 75% amount, and rather, approaching the high courts under writ jurisdiction directly in order to bypass the entire statutory scheme. And in that case, the Supreme Court held that this cannot be the outcome, because then this obviates and negates the intent with which the MSME Act was brought in. And so therefore, that judgment states that writ petition in MSME cases will not lie. So there are two contradictory judgments in this forum. However, I think, in my view, that they operate in a very separate field. I mean, while they both stand to be true, because they both deal with different factual scenarios and they both deal with two different evils. In the first case talks about, which is Jharkhand Urja Nigam Limited, that talks about a scenario where the MSME Council itself did not follow the statutory mandate, and so therefore it was a non-award. And so therefore, in that case, there was no statutory remedy available against the buyer, and therefore it was correct to state that writ remedy would be available. However, in the other case, to say that the buyers are trying to short circuit the statutory mandate and trying to avoid the statutory mandate by invoking the writ jurisdiction is also not incorrect in that particular factual scenario, and it was right to do so. However, the mistake that the judgment did was to extend it to a blanket ban from exercising such jurisdiction, which has also been considered by the Supreme Court recently in Tamil Nadu Cements Corporation Limited, and it also has referred the issue to a larger bench for reconciliation, because it also does not agree that while the two judgments operate in different spheres, but they can never be a blanket ban on exercise of writ jurisdiction, which is an extraordinary power. Now, the second issue would be reference of a dispute to MSME counsel by an MSME is maintainable only if the MSME was duly registered under the MSME Act at that time. So this issue I've already dealt with it, and I need not repeat myself again. The third issue is lack of arbitration proceedings by MSEFC while adjudicating the dispute. Whether the MSME order will be considered valid given the lack of arbitration proceedings, would a writ petition be filed to challenge the order despite alternate remedies? This is also that has been covered already. Now, overriding effect of MSME Act over the Arbitration Conciliation Act, this is also something that I've already discussed and has been dealt with by Supreme Court in several judgments, and the latest being the Gujarat Supplies versus Mark Ali Foods. The other fifth issue is with respect to maintainability of Section 11 petition, which is for appointment of an arbitrator during the pendency of MSME reference. Now, this is quite a unique case which is Ballav Corporation, and this is a judgment by the Delhi High Court. Now, in this case, what had happened is that the MSME Council itself, once the reference was made, it was neither acting on the mediation, neither initiating the mediation nor the arbitration. I mean, there was no action at all from the MSME Facilitation Council. And so, therefore, in that situation, what is the remedy available is something that was considered in this case. And so the judgment went on to say that in such situations where the MSME Facilitation Council itself fails to act, the remedy under Section 11 of the Arbitration Conciliation Act, which is to approach the appropriate court for appointment of the arbitrator, would be available. So this is an interesting issue which has been decided upon and something that can be considered, because the objection that was taken by the buyer in this case was that once the process under Section 18 of the MSME Act has been started, no other court can interfere. Which basically said that, look, once the process has been initiated, reference has been made, the ball is in the MSME Facilitation Council's court, and so therefore we should wait for them to act rather than assume jurisdiction. This argument was, however, negated as pointed out, and the court held that you can approach. So therefore, it's a shot in the arm for suppliers in cases where there is no action by or a complete inaction by the Facilitation Council. Now, these are issues that we have already discussed. So given the limitation of time, I would skip through them. Now, what are the implications on MSMEs and legal strategy in mitigating risk which arises from it? So therefore, what I can perceive is that, firstly, I think there has to be an education as to, all the MSME units have to educate themselves as to what rights exist and what are their privileges and benefits that are being granted under the Act unto them, and therefore, in order to avail those benefits, and given the legal uncertainty, proactive registration is something that should be taken up by the MSME entities, where they register themselves under Section 8. There is a portal, Udyam portal, on which they can register themselves. So what happens is that once you have that registration, there is already a existing proof that you are an MSME, and so therefore you need not prove otherwise or take a secondary argument that that registration is not mandatory. So that would obviate or eliminate that confusion or ambiguity from the very beginning if you are registered. Secondly, is, as I pointed above, is to have clear contractual terms where you stipulate whatever is the terms according to the MSME Act, which is the payment liability obligations, the duration of the payment, consequences of delay, and the fact that the arbitration would be as per the MSME Act, and not have contrary clauses where it provides that the arbitration would be according to some other law and the seat would be somewhere else, and so that there is no confusion subsequently. Thirdly, would be to seek legal counsel. I would suggest that whenever, of course, while you are conducting business, you would be facing several legal issues from several sectors, be it labor law, contractual disputes, from regulatory perspective. If you are someone who's acting or operating in the league, with metrology. From units, if you're selling units, you would be obligated to follow legal metrology act. If you are dealing with food products, then you would be obligated to observe the rules and regulations under food safety. So therefore, there are there are a spectrum of laws which you need to comply, and so therefore it would be beneficial for everyone to seek legal counsel whenever an issue arises, or even before that, so that you can preclude any future issues with respect to liabilities under any other statute. And fourthly, I would say that there should be no delay on your part in availing a legal remedy. So if there is a delay in payment, or if there is an issue, you should swiftly act and approach the facilitation council. You should not delay anything from your end. And ultimately, once you have an award or a mediation settlement, you should swiftly act towards enforcing the award, because the swiftly you act, it would cut down on the delays which can be occasioned by the casual approach of the other side. Now, the other segment which I also want to deal with is if there can be a criminal action initiated by buyers which are parallel to MSC FC proceedings. Now, there are instances now where, for instance, the payment has been made by the buyer by a check, but once you present that check, the check is dishonored. Now, in such situations, of course, you should know as to what to do. You have a legal remedy available under the Negotiable Instruments Act, which deals with dishonor of checks. So the moment there is you bang the check and there is the check is dishonored, you have 30 days to raise a demand against the defaulting party. And once that demand is not met within 15 days, you can file a criminal complaint for dishonor of check under Section 38 of the Negotiable Instrument Act before the court, which has the jurisdiction over the bank where the check was presented. Now, just to tell you a little more about the Negotiable Instruments Act, it's not a recovery proceeding as such, but it seeks to penalize instances where people knowingly dishonor a negotiable instrument. So in order to prevent frequent dishonoring of a negotiable instrument, there is a criminal liability which has been attached to such acts. However, once a complaint is filed and before its disposal, if the buyer in this particular case, in this instance, if they make the full payment of against the defaulted check, the case can be withdrawn. So therefore, in effect, although it's not a recovery proceeding, there can be a recovery that can be made. Apart from this, the other issue that I see is that issues are issues where there is a case of cheating or dishonest misappropriation of property or criminal breach of trust, which happens. So suppose, for instance, there can be a scenario where a buyer approaches you and says that you supply these goods to me and I will pay you such and such amount. And although it doesn't have the intention to pay, but only seek delivery and then disappear. So in such cases also you can file a criminal complaint for cheating or criminal conspiracy if the facts so disclose. And they can be and this remedy can also be pursued along with the civil action, which is the arbitration and the conciliation process before the facilitation council, and these two can run parallelly. And as in under Indian law, these two have different consequences, although they arise from the same cause of action. The nature of cases are different, and so therefore they can be parallelly pursued. So the effect of ensuring legal advisory is essential for following reasons. I mean, I need not repeat. I will share the slide with ISFA, and it can be these facts, these points have already been captured beforehand, and so therefore I need not repeat myself over again. And I think that would conclude my bit. I would hand over to Neha to take it from here and present and take you through issues with respect to intellectual property disputes. Thank you once again. Hi Neha, over to you.
Hi. Hello, everyone. So I believe that we have a limited amount of time now. So given the fact that I'll just quickly share my screen and we'll quickly go through the intellectual property aspects of it. Just give me a minute. Is my screen visible? You all can let me know.
Yes, your screen is visible.
Okay, sure. So what I'll do is I'll cover the introduction quickly so that we can get on to question answers a little bit earlier. So I will cover the intellectual property aspects. What happens is what we've seen in general clients, as Aman correctly pointed out, that MSME forms a very substantial and a large part of our business ecosystem in India. Now, given, sorry, given that basically today it is important for MSMEs to understand what kind of IP they produce or create and how to protect it. So what happens, why is it important for MSMEs to protect their IPs? Firstly, it gives them exclusivity. It gives them a competitive advantage over other MSME or other players effectively. And in case your MSME is interested in furthering research and so on and so forth, it is very essential to protect your IP right from the start so that you sort of avoid any seepage eventually. So what kind of IPs are there if if I may just explain quickly, there are various types of IPs which should not ideally be confused with one another. We'll go into each one of them briefly, but to sort of capture it in one go, they're divided into patents, copyrights, trademarks, designs, trade secrets, and geographical indications. So these are the types of IPs which the Indian legislature covers. First one, what we will talk about is a patent. Now, I have seen a lot of our clients getting confused between what is a patent, what is a trademark, what is a copyright. It is very essential to understand that patents are something that are very, very connected to something that is an invention. What you see on a box or on your computer as a logo, they are not patents, they are trademarks, and they fall into a separate compartment of intellectual properties, which are called trademarks, and there are several categories to that as well. But if we take patents as first, if you're an MSME which is heavily into research, any product or process which basically can be termed as an invention, which is a furtherance of the technology which is presently available, could be a patentable product or a process. So it is very essential for the MSME to identify this, for which there are experts like us, to identify whether it is an invention or not, firstly, and if it is yes, then it is patentable or not, and so on and so forth. Now, a patent will give you a monopoly to produce that product or use that process for 20 years in India. It's a territorial, protection, and if you have a patent which you have to use anywhere else, you have to register it in that specific country as well. Generally, there are few things which are not patentable, which methods of agriculture, which will sort of benefit the public at large. This is something that the government will not allow you to patent, or atomic energy related issues. But anything which is in the field, which is in furtherance of inventions in the field, is a patentable product or a process which is allowed in India. The second kind of IP which we can discuss are copyrights. Now, copyrights are something which, especially for MSMEs who are into some kind of creative fields where they end up producing something creative, or even in terms of software. So copyrights are divided into various category of works, which are literary works, artistic work, musical works, or dramatic works. Now, literary works is a base category of copyrights, basically, which considers anything which is written down on paper. So the moment you think that whatever you've written down is something very unique, it may be anything as simple as your, the content on your website, even that is copyrightable. Or some concept that you also concept as a copyright doesn't exist, but it is always beneficial to go and register something which you feel is unique and you've put down on paper. Also, any art that you create for an MSME, which is suppose, into digital art or any such kind of thing, unless it's commissioned by someone and your consideration is paid for it, you must consider getting copyrights for any kind of art that you create, or a script that is written, or any artistic work, photographs, paintings, drawings, anything that is done. Even software, which is a most important kind of copyright, falls into the realm of literary work. So if you have basically invented a software which is unique, which does something which is not available in the market, even that software is copyrightable as a literary work. So copyright in terms of infringement, you should be aware that when anybody uses your product, please bear in mind the fact that copyright is not something like a patent or a trademark. It is not compulsorily registrable. You need not register it for it to be yours compulsorily, but nonetheless, it is very essential to register the copyright so that it gives you some kind of priority advantage, because when you register it, it forms a part of the government records. That gives you some kind of a document to show that this is when I had applied for my registration and I am a prior user. So that is something that is to be borne in mind. The third and I would say the utmost important category for anybody to bear in mind would be trademarks. Now, trademarks is as you all know, trademark is something that you see on any product or a service. It's a particular mark, name, or a logo which will identify or distinguish your service or goods from other people's service or goods. Anything that falls in that realm forms into the category of a trademark. It's a symbol basically, or a name which will identify your product. It will establish that consumer relationship with you all. So everything that you see around you are generally trademarks which are pasted on the product. So this is the most important. Registration to claim exclusive rights is compulsory, although there is also a method where in case you are not registered, then, and if you're using it for certain number of years, there's this goodwill which is attached to your trademark which will come into play and also protect you. But obviously registration to assert exclusive use in a territory, sue the infringing party within your jurisdiction where you conduct business is all important for asserting your rights in your trademark, because of which registration becomes a very important factor. The second last category which we could discuss is designs. Now designs is something which it is a kind of copyright, but it is not really into the copyright intellectual property zone, because it's something that only purely deals with the 3D and 2D aesthetic of a particular product. It has got no utility advantages. In a copyright, maybe you could, register some artwork which has a particular utility advantage or anything like that. It is a kind of copyright because it has to be submitted in an art format, but it has to have a pure aesthetic value to a product. So some of the examples would be the design that you see on a fabric, or the design of a jewelry, which has got no utility, but it's just aesthetic. Lighting equipment, electronic devices, which just look good in a particular way. The technical aspects of it will not form part of design protection, but the way it looks and how it distinguishes your, larger design from others is something that will form part of design. It's very essential for fashion designers, fabric producers, or any people who make any unique looking items which have got no utility, but it just looks a particular way that distinguishes your product from the others. One thing that is also forming part of intellectual property is trade secrets. Now what happens is sometimes there are there is some kind of intellectual property in in a method or in some data, but you don't want to reveal it to the authorities, or you want to keep it hidden. You don't want to put it as a part of public record. It could be as simple as your customer data, or the way you do things. The most famous example of a trade secret used to be the Coca-Cola formula, which is not patented, not copyrighted or anything. It was just kept as a secret. So you can also sort of protect your intellectual property in this fashion. It is the most it is not the most secure when it comes to protecting, but there may be certain confidential data which sort of you don't want it to become part of public records, to which then the trade secrets common law applies, and there are methods to keep it secret, and forming agreements with parties who you reveal it to. So those are the kinds of intellectual property which are called trade secrets. The last kind of intellectual property which we can touch upon are geographical indications, which are very specific to products established and produced in a particular area or a territory in India, like a Kolhapuri chappal or a basmati rice. These are geographical indications. So if you're into such kind of production of such kind of products, you can apply for a geographical indication tag, and once you pass the test whether your product sort of satisfies those, you get a GI tag, which helps a lot in business. So I'll just cover this very quickly. Basically, benefits of a patent registration would be that it gives you monopoly for 20 years. It sort of also confers you right to license the product or the process to further, users, which otherwise would not have been available because you wouldn't have the right. Royalties also is one part of the, business benefit that you get from patent registration, is because on a license or on an assignment, royalties is chargeable by the owner to the user. Secondly, coming to registration of a copyright, like we said, it is not compulsory, but it gives you advantage in terms of creating a paper trail before the government, giving you the priority. And obviously, if you're licensing your work, so on and so forth, it gives you that advantage also, and to negotiate your royalties, etc. Trademark registration, I would say, along with patents, is one of the most relevant kinds of registration. It gives a message to the public at large that today I am claiming rights in this trademark. Otherwise, if it's not available for people to search, then if somebody else starts using it in another part of the country, it becomes a very, a very strong case for others to say that we were not aware of this. And then there is also a chance of that being allowed further by the courts unless you have gone ahead and registered your mark. Design protection also, we will be sharing the slide, so we can skip that, and so on. GI benefit tax we've already gone through. Okay, one last topic which I would like to touch is in valuation of your IP. Basically, a valuation is something that all this registration, keeping your IP in a particular formatted manner, having hold over your IP in terms of jurisdiction, how to register it, keeping a very, tracked kind of an IP system that will help you valuate your IP eventually. What happens is sometimes you don't recognize the value of your IP, and when your business grows and you want to sell it or franchise it or things like that, valuation comes of utmost use, because the value of your IP is what sometimes will up the consideration that you are going to get on sale or franchising or licensing and so on and so forth. I've just gone through this. Basically, in case IP is basically an asset. So in case you're looking to use this asset, to mortgage it and so on and so forth to get some funding, that's something that IP can be used as to attract investors and partners to increase your business. And obviously, if your IP is very highly valued, settlement of disputes, course of action is also one thing that can, come into play. And sale of IP, obviously, valuation comes in a very heavy use when you are selling your IP. So that's it for me. I have sort of gone fast with it, but I hope you all have sort of, understood the point that we're trying to make here.
Thank you very much, Neha ji. I am sure that we have missed your presentation details, which is really helpful for our franchisee startups and MSMEs. But we definitely make sure we arrange next session for IP only, because I think it's a very vast topic.
Yes.
And we have lots of things to discuss on this. So in our next session, we discuss in detail. So we have a few queries in our Q&A box and chat box, and I also received 3 to 4 questions in my personal chat. So I can paste the same also for your reference in chat box. So should we start with the Q&A first?
Yes.
So there is one question which I saw, which was with respect to what happens if a buyer's PDC gets dishonored. Are there any financial penalty and criminal protection to the MSME? Now, PDCs are generally, although they are to be, PDCs are something that become payable at a future date. So as long as they are valid on the date of presentation, and as long as there is a clear pre-existing legal debt or liability to pay, even if the PDC has been used as a security, the right under 138 to file a criminal complaint or prosecute the person for dishonor of that check will still be available. So to answer your query, that yes, you can file a case under 138 of Negotiable Instrument Act if PDCs are dishonored at the date of when they are supposed to be presented. Are there any other questions with respect to the Facilitation Council or the the dispute resolution side of it? Happy to take it.
We have a question in Q&A box. If I GI tag a food of a city, how it helps me in stopping my competitors in producing same food of that city? Can they be stopped?
No, so
Nearly.
yeah, so GI tag is given to any producer who produces that product and matches. There are certain standards kept for each product. So not one producer will be given a GI tag. There are many producers in that geographical area which will be given your product will be given a GI tag, certifying that your product matches the GI tag standards for that area. So it is not just one person. There will be many, but if you produce that product and you apply for a GI tag and it is found that your product is basically passing the threshold to get a GI tag, then you will be certified, under the geographical indications, threshold. So it's not about stopping others, because it's not one person producing the product, right, to stop others.
Next question we have, IPR is become a legal and costly issue or suddenly open source. How we can protect our small MSME IPR with protection? The similar question I also received in my personal chat also. Is there any government subsidy and the grant is there to apply for IPR
So
and
for example, for fees of trademarks and all, startups and all have a lower government fee. So there is subsidy when it comes to government fees. For body incorporates and things like that, the government fee is higher. For startups and MSMEs, the government fee is lower. So you have to, depending on your turnover, you have to fit yourself in that category and the kind of entity that you are. So government provides subsidy in the form of lower government fees. What they take out of it is then lower, charged on a lower threshold.
can idea be patented?
No, an idea can't. It's very specific. It has to be a product or a process and an invention. Basically, what is the inventive step in that product? Or if it's a process, then it has to be a working process. There has to be research, experimentation, and trial runs done on it for it to. It has to be a working kind of a product or a process. It's not only an idea.
How can I protect my brand and or product from being copied in international market?
So the intellectual property right laws in India today are territorial. If you register your trademark in India, identify the countries where you are going to use your product and get registration in those. There are two ways to do that. One is going individually to those countries and appointing lawyers or agents and getting the registration, or there's something called as a Madrid protocol, where it is restricted to the countries who have signed up for that protocol. So if you make an application in India, you can make a connecting application to the protocol registered countries from India only. And then the registry sends it to those specific countries, and then it follows the registration process in those specific countries. Although I would like to add that the fee is not anything lesser, because each country that you add to your list, the fees getting added up, because you pick one country, the fee of that country will get added up. You pick a second one, that registration fee of that country will get added up. That's one method. Or you do a separate application to countries where you know that you're going to use your products or services in. That's one way to protect it internationally. There's no global kind of thing where I make one application and everywhere it gets protected. That's not there, right?
So due to paucity of time, I'll just take a last question. We have two, three more questions also, but I can take last one. How do I manage IP ownership?
So that's a very vast, wide kind of question in terms of management. I would say that start with basically sanitizing the what kind of IP you have. Start segregating it. Start making sure that you file the relevant documents to assert your ownership. Do the right kind of registrations in right kind of classes. Maintain a tracker or a proper chart of what IP you own, what is the jurisdiction of it, what are the classes. All this helps. And if any registration is getting lapsed, then you all have to make sure that they are renewed within the relevant time. Also, in terms of your licensing, you also always have to be careful that if you want to retain ownership, you give out the right kind of license for the right kind of territory and not give away your rights, So that's a very basic, thoughts on your management of your IP. If you have everything clear, then obviously further sale or licensing from your side becomes much more easier.
Thank you very much for your detailed presentation. And participant, we will share the presentation with you after the session. And if you have any more query, you can write to us, or either you can write to our speakers directly. We share the email ID of our speakers to you along with the presentation. So, and you can also approach them for any professional query also. So thank you very much, Nehaji, Amanji, for your detailed presentation, and thanks for Phoenix Legal for supporting this session. And we look forward many more session on this topic, because people are very keen to hear on these topics from retail segment especially. Thank you very much.
Thank you.
Thank you.
Thank you so much.
Thank
Thank
you.
you, everyone.